just 6 judges. Given all of these circumstances, we are waiting for the all clear from Will. Okay, he says we can go, so you guys are welcome to start. And I'll turn it over to Judge Kohler.
Great, thank you. So as you heard, we got the all clear. So I'm going to go and call case of Stevie Rogers versus Drew Mars. My name is Judge Kohler. Scoring judges, please look to the bottom 2 buttons on the lower left of your screen and remember to keep your audio and video off unless the bailiff tells you otherwise. You should also have your video set to hide all non-video participants. This means the only people on the screen right now should be me and the advocates. Attorneys, can I get appearances?
Yes, Your Honor. Starting with the plaintiff, my name is Ellen Wandrow, and I'm here with my co-counsel, Delaney Cornforth.
Good afternoon, Your Honor.
And together, we represent the plaintiff in today's case, Miss Stevie Rogers.
Good afternoon, Your Honor. Hello, my name is...
Oh, sorry, my apologies.
That's all right. Hello, on behalf of the defense, my name is Julie Musto, and along with my co-counsel, Andrew Dubsky, will be representing Drew Mars in today's case.
Great.
Good afternoon, Your Honor.
Oh, my apologies. Go ahead.
Good afternoon, Your Honor.
Good afternoon to all of you. Do we have any pretrial matters before moving into opening statements?
Yes, Your Honor, the plaintiff would just like to call the court's attention to a few evidentiary rulings that were made prior to trial. First, evidentiary ruling number 14 states that Detective Bond and Ryan Cabrera will be constructively sequestered. The parties, Rogers and Mars, will not be sequestered. Pursuant to that rule, our party representative will be Stevie Rogers. And other than that, we wanted to call your attention to evidentiary ruling, I believe 19, though my numbering may be off. It may be number 20. Through no fault of either party, Detective Nora Khan is unavailable within the meaning of MRE 804A.
Okay, the court will take note of that. Do you have anything else?
No, with that, Your Honor, the plaintiff is ready to proceed.
Great. How about defense?
Yes, Your Honor. We would like to make note the court that exhibits 1 through 7 have already been pre-admitted into evidence, as we will most likely be using them throughout the trial, so they do not need to be re-admitted. In addition, since it is the first time we are in your courtroom today, we are wondering about your preference when making objections and whether to refer to you as Your Honor or simply as a member of the jury.
Feel free to refer to me as a member of the jury or Your Honor, whatever is most convenient for you in that moment. In terms of other preferences that I might have, I would ask that for objections, you object and state your grounds. And then whenever you plan to use any demonstratives, if you're planning to screen share any evidence or anything to that effect, no need to ask to screen share. You can simply screen share, and then we'll deal with any objections that opposing counsel might have after you go and do that.
Yes, Your Honor. And with that, the defense is ready to begin.
Great. Opening statements from the plaintiff then.
Yes, Your Honor. May I proceed? May it please the court, counsel, members of the jury, the proof is in the prints, and the prints are on the pills. Today, you will be hearing about the life and tragic death of Miss Agatha Lee. Miss Lee was a successful author who gained critical acclaim from her single published book, Death in a Bottle. As you will soon learn, she suffered from a severe allergy to an over-the-counter heartburn drug, so severe that a heart attack in reaction to the drug had already rendered her unable to live alone without a caretaker. This is where Drew Mars, the defendant in today's case, came in. The defendant was Miss Lee's caretaker for 10 years, and in February of 2018 was declared to be the sole heir to Miss Lee's more than $20 million estate. But in July of 2018, Miss Lee's last living relative, her granddaughter, Stevie Rogers, came to her house and began to rekindle the close relationship that they'd shared from years before. Unfortunately, this rekindling was soon interrupted when Miss Lee was found dead. On the morning of August 15th, 2018, a private investigator and police detective were called to the scene. At first, it was thought that Miss Lee had died of old age, but her granddaughter insisted upon an autopsy, which found that Miss Lee had been poisoned by the same over-the-counter drug that she was allergic to. An investigation into Miss Lee's death found fingerprints that suggested that her nightly prescribed arthritis medication had been swapped with the fatal over-the-counter pills that she was allergic to. Members of the jury, as you will soon learn, the proof is in the defendant's prints, and those prints are on the pills. At this point, I'm sure you have a lot of questions, but let's take a step back and clear up exactly what you're being asked to decide upon today. You are here to determine whether the defendant is liable for the wrongful death of Miss Lee. Wrongful death is most easily explained as when a person knowingly or purposely causes the death of another. As the plaintiff, we have the burden of proving this to you by a preponderance of the evidence, which simply means more likely than not. If by the end of trial today, you find that it is more likely than not that the defendant knowingly or purposely caused the death of Miss Lee by swapping her prescription medication with that over-the-counter drug that she was allergic to, then you must find the defendant liable. Throughout trial, you will hear evidence that will aid you in finding your verdict. Let's start with how the defendant knew that the pills would kill Miss Lee. You will hear how the defendant not only knew about Miss Lee's allergy to the over-the-counter medication, but that he knew that if he were to swap one pill for the other, Miss Lee would take whatever he handed to her, because the defense's own witness, Miss Cabrera, heard Miss Lee tell him so. You will learn that even if the pills were swapped, Miss Lee couldn't have known the difference because the over-the-counter pills and the prescription medication that she took every night were identical. You will hear about a bag found in the defendant's closet with the defendant's fingerprints found on its handle. And on the inside of the bag, a bottle full of the over-the-counter pills that killed Miss Lee. Another bottle full of harmless prescription medication was found in the bathroom, and exactly 2 of those pills had the defendant's fingerprints on them. The proof is in those prints, members of the jury, and the proof leads to the defendant. You'll also hear about why the defendant would do this. You will hear that once her granddaughter returned and they were able to rekindle their relationship, Miss Lee planned to change her will to name her granddaughter the sole heir. Eyewitnesses and evidence will show you that the defendant knew he was supposed to inherit the money in the previous will, and that he knew it was all about to be taken away. The defendant poisoned Miss Lee by swapping her pills in order to prevent this from happening, leaving behind a grieving granddaughter, an empty house, and as you're going to learn, the defendant left one more thing behind: a series of damning fingerprints. At the end of trial today, my co-counsel is going to come speak to you. She's going to walk you back through all of the evidence, showing you again how the proof is in the prints. And she will ask you to find the defendant liable for the wrongful death of Miss Lee. Thank you.
Thank you, Ms. Cornforth. Defense?
Yes, Your Honor. Ladies and gentlemen of the jury, may it please the court. Stevie Rogers was family in name only, But Drew Mars was so much more. On August 14th, Agatha Lee unfortunately passed from an allergic reaction to chlorandramine. Any amount in her system would have killed her. And you will hear that on the day of her death, there was 500 milligrams in her bloodstream. The first person to find her in the morning was her dear caretaker, Drew Mars. When he found that she had no pulse, he sank to the ground in disbelief. You will hear that for over a decade, Mr. Mars was beside Miss Lee every day, caring for her and keeping her company when she had no one else to turn to. Miss Lee's only grandchild, Stevie Rogers, was out touring the world and had not spoken to Miss Lee for over 8 years. Meanwhile, Mr. Mars was there for over a decade of birthdays, holidays, and supporting her on every anniversary of her child's death. In 2018, Miss Lee changed the benefactor of her estate from her grandchild by blood to the person who cared the most for her in her final days. That is why Miss Lee left everything to Mr. Mars. Now, the plaintiff, Miss Rogers, is trying to convince you, members of the jury, that they are entitled to an estate of a grandmother that they left behind. Now, in order to convince you of this, the plaintiff must show you the preponderance of evidence that Mr. Drew Mars played a part in her death. This means that the plaintiff must show you that it is more likely than not that Drew Mars, her doting and loving caretaker of 10 years, was somehow involved with her death. However, they will be unable to show this, for we, the defense, will present evidence to you to show that Mr. Mars had absolutely no involvement in the death of Agatha Lee. To prove this, we will call forward 2 witnesses. The first witness we will call is Drew Mars himself. He will speak to his experience with Miss Lee and how they developed a grandmother and grandson relationship over the course of many years. He will speak of his duties to her, how he cared for her, and how she was like a grandmother to him. He will tell you how Miss Rogers reacted angrily after they were denied Miss Lee's inheritance. They will testify that Miss Rogers had unlimited access to the Lee Manor, including a room where the very medication that killed Miss Lee was stored. Next, the defense will call Ryan Cabrera, the biographer for Miss Lee. She will testify to the close relationship that Mr. Mars and Miss Lee had formed, that when Miss Rogers appeared at Lee Manor after nearly a decade of no communication, that Drew felt protective of what Miss Rogers may do. And she will describe the conversations with Miss Lee about Miss Rogers, how Miss Lee expressed that she was so lonely and neglected by Miss Rogers that she decided to change her will to exclude her from it, that at the end of the day, Rogers was family only by name, but Drew Mars meant so much more. At the end of trial today, you will be able to see the whole story. You will have heard the story of a caretaker that was more like a grandson than Miss Lee's actual granddaughter, how he grieved her death and the end of their close relationship, how Miss Stevie Rogers was family in name only, and how Mr. Drew Mars truly cared for Miss Agatha Lee. And at the conclusion of trial today, my co-counsel, Andrew Dubsky, will come before you and show you that based on the evidence, there will be no proof that the will should be overturned, and that you cannot find Mr. Drew Mars liable for the death of Miss Agatha Lee. Thank you.
Thank you, Ms. Musto. Now, before the first witness, we would ask everyone to make sure they've switched to gallery view. That button is in the upper right of your screen. This will allow you to see the attorneys and the witnesses at the same time. And with that, is the plaintiff ready to call its first witness?
Yes, Your Honor.
Yes, Your Honor, at this time, the plaintiff calls Michelle Bond to the stand.
Feel free to proceed whenever you're ready.
Yes, Your Honor. Please state your name for the record.
The name is Michelle Bond.
What do you do for a living?
I'm a consulting detective. When there's a private inquiry or when the police are out of their depth, which is most of the time, they consult me.
Do you have any credentials or experience which qualify you as a consulting detective?
Yes, I have a private investigator's license here in Midlands, and I've also been a consulting detective for decades. Many of my cases made the papers, but I'd say the most famous of them were, The Tragedy of the Part-Time Wardrobe and The Secret of the Meticulous YouTuber.
How are you involved in today's case?
I was hired by Stevie Rogers to investigate quite the peculiar case, the Manor murder.
How did you first become involved?
Well, I got a call precisely at 8:45 a.m. on August 15th of 2018. It was Mr. Rogers, and the news was riveting. Rogers claimed that his dear old Nana had been murdered, and he wanted me there as soon as possible.
Objection, Your Honor, to hearsay.
Can I hear argument from the plaintiff in response?
Yes, Your Honor, we are not using this for the truth of the matter asserted. In fact, we are here to determine whether Miss Lee's death was caused by the defendant. This is simply for the subsequent action of Miss Bond in coming to the manor because she had been told by the plaintiff that his Nana was murdered.
Defense response?
I stand by my objection, Your Honor. I believe that the witness has just elicited hearsay, and that is an out-of-court statement being used for the truth of the matter asserted, regardless of whatever other context it may have had.
I'm going to overrule the objection for now and issue a limiting instruction to the members of the jury that this is only being used for subsequent action. If you feel that in their line of questioning that follows this, they are delving past subsequent action, feel free to raise your objection, but for now I'm going to overrule.
Yes, Your Honor.
Miss Bond, how did you first become involved?
I got a call precisely at 8:45 a.m. on August 15th of 2018. It was Ms. Rogers, and the news was riveting. Rogers claimed that her dear old Nana had been murdered, and she wanted me there as soon as possible. I arrived at the Lee Manor at 9:25 a.m.
What happened when you arrived at the manor?
Ms. Lee was dead, all right, but there was no blood. There was no bruises or cuts that I could see on her body. So just an 82-year-old woman found dead in her bed. Well, at first glance, it seemed as if Miss Lee had passed from natural causes. Now,
Objection, Your Honor. This time to speculation.
You have a response?
Your Honor, the witness just stated that upon her arrival, there was no blood. There were no bruises or cuts that were seen. It was just an 82-year-old woman laying dead in her bed. This is based off of her rational perceptions that she saw at the time.
I'm going to agree and overrule this time.
Yes, Your Honor.
What happened when you talked to Detective Khan?
Well, I've met lead detectives who lower the IQ of the entire room when they open their mouths, but Detective Khan was definitely not one of those detectives. With a little convincing, she ordered that an autopsy be performed on Ms. Lee.
Were you able to review that autopsy?
Quite so.
What did you learn from it?
There were two kinds of pills in Miss Lee's body, good pills and bad pills.
What did you mean by good pills?
Well, as I learned from the defendant, the good pills were the ones Miss Lee would take together every night before bed, which included aspirin, vitamin B, and a prescribed arthritis medication.
What did you mean by bad pills?
The bad pills were chlorandramine, an over-the-counter drug used to alleviate heartburn. Chlorandramine in Miss Lee's system may not have been noteworthy, had it not been for one slight issue. Miss Lee was deathly allergic to it. I also learned that from the defendant.
I'm showing you what has been marked as Exhibit 12. What is it?
Well, that is a picture of Miss Lee's pill organizer on the morning that she was found dead.
How do you recognize it?
Well, I saw the pill organizer itself during my investigation.
Does this photo accurately represent what you saw?
Yes, it does.
At this time, the plaintiff enters Exhibit 12.
Any objection from defense?
No objections, Your Honor.
We'll accept Exhibit 12 and publish to the members of the jury.
What pills did Miss Lee take the night before she was found dead?
The night before Miss Lee was dead, she should have taken all of her good pills, like she did every night before hitting the sack. Her pill
Objection, Your Honor. Again, to speculation this time, I believe that this witness has no knowledge of what she could have taken the night before, only to suppose.
A response?
Your Honor, as the witness previously stated, she discussed with the defendant during her investigation what pills Miss Lee would take every night. And therefore, she also said during her answer that the pills that she is saying she should have taken every night. Therefore, this is also based on her rationally based perceptions from the things that she discovered during her investigation and simply from looking at the pill organizer.
If I may, Your Honor?
You may.
The very fact that she has to suppose that what pills were taken last night and that she wasn't present for having those pills being taken proves that she is speculating.
I'm going to tend to agree with defense counsel and say that if you want to get into that testimony, I would lay more foundation. I think right now it is verging into lack of personal knowledge, or we haven't heard any foundation to understand how she knows that information. So if you want, I would ask.
Excuse me. Yes, Your Honor. Ms. Bond, what did the autopsy tell you about the pills in Miss Lee's system?
The medical examiner found that she had only taken 2 of her good pills, vitamin B and aspirin. She hadn't taken her arthritis medication in 24 hours. In place of those 2 arthritis pills she normally took were 2 heartburn alleviation pills. It was obvious to me what had happened.
Were Miss Lee's arthritis pills similar in appearance to the heartburn pills?
Yes, her prescribed arthritis pills looked completely identical to the heartburn pills she was severely allergic to.
Where did your investigation lead next?
Well, I decided to do some good old-fashioned snooping. I looked through the defendant's bedroom and found their laptop. There I found an email the defendant had sent to what seemed to be her friend. I took a photograph of the email.
I'm showing you what's been marked as Exhibit 13. What is it?
Well, that's a picture of the email that I found on Drew's laptop.
Does it appear to be the same as the last time that you saw it?
Yes.
The plaintiff enters Exhibit 13.
Any objections?
Yes, Your Honor. I object to hearsay within hearsay.
Feel free to argue that a little bit more.
Yes, Your Honor. The first layer of hearsay I'd like to draw your attention to is the statement in the body of the email itself. This is a out-of-court statement being used for the truth of the matter asserted. Secondly, I'd like to pull your attention to the hearsay of the document itself. It is an image of a Gmail account, which is a type of email account, and there are statements in the entirety of the picture that are being used for the truth of the matter asserted, such as the email addresses, the subject lines, and also the time of date, the timestamp, if you will, of the email itself.
Do you have a response, defense?
Your Honor, regarding the statements from Drew Mars, we are only using the body of the email sent by Drew Mars. We would be fine with constructively redacting every other piece of the Gmail setup, but we are focusing simply on that. Regarding the the statement by Agatha Lee, the hearsay within hearsay, this is an exception to hearsay under Rule 8033, specifically Miss Lee's motive, intent, or plan to leave everything to Drew Mars, to have Drew Mars be her sole inheritor.
Defense, do you have a response to the proposed redaction as well as the 8033 argument?
The defense would be amenable to redacting all of the words on the screen with the exception of the body of the paragraph.
Okay, so that takes care of that part of the objection, but I understand you're still objecting to the hearsay within that body. Do you have a response to counsel's 8033 response?
In the words of Agatha Lee, to clarify?
Yes.
We are amenable to keeping those in.
Okay, so to clarify, we're redacting everything except the body of the email, and with that, we'll accept Exhibit 13.
Yes, Your Honor.
Your Honor, would we be able to not redact the dates, the timestamp at the top of the email included with the email, as well as the sender, but not the receiver of the email?
Defense counsel, is that what you were objecting to originally?
Yes, that is one of those layers of hearsay that I mentioned earlier. That is part of the Gmail format that I expressed an objection to.
Okay, so opposing counsel, do you want to argue for why the date and time as well as the sender should be included?
Yes, Your Honor, one moment. Your Honor, this is also an exception to hearsay under Rule 803, I'm sorry, 8036, a record of a regularly conducted, 8038, a public record. No, 8036, I'm so sorry. 8036, records of a regularly conducted activity. Now, this record was made at or near the time by or from information transmitted by someone with knowledge. That would be Drew Mars. And we see the timestamp. The timestamp is when the email was sent on February 1st, 2018 at 9:24 p.m. It was kept in the course of a regularly conducted activity of a business, being the business of Google. And the record is made as a regular practice of that activity. And this is shown by a custodian or other qualified witness. This is shown by someone who took a picture of this email, seeing it in its entirety with all of these other prongs fulfilled.
Mr. Dubsky, do you have a response to plaintiff having met the prongs of 8036?
Yes, Your Honor. I would like to say that I disagree with this exception, primarily in that the works of Gmail is not a regularly conducted business for Drew Mars, who is the recipient of this, or who is the creator of this email. And the fact that it's not conducted in their business makes this completely irrelevant to those statements. Additionally, the conditions of this email are not shown by a custodian of this email or of another qualified witness. Simply being a user of Gmail or having taken a picture of this computer screen does not make them a qualified custodian. For that, we would need someone from the organization Gmail or Google itself.
Your Honor, may I respond on those grounds?
Final response.
Your Honor, under case law Empower Milk Inc. v. Anderson 2019, you will find it on page 2 of the available law. It reads that as long as the proponent of the statement produces evidence that would permit a reasonable jury to find by a preponderance of the evidence that a given person made a particular statement, the court must assume for purposes of assessing its admissibility that the statement was made by that person. Now, this is Drew Mars' email address. These are statements that if we are allowed to continue through trial, you will find will be backed up by Drew Mars' testimony and the testimony of other witnesses. Therefore, there is evidence that would permit a personal jury to find that it is more likely than not that Drew Mars made this statement and that email was sent by Drew Mars' email address at the top of the email.
Okay, great. Given the case law, I'm going to admit the exhibit with the name of the sender, the date, as well as the body. Feel free to continue.
Yes, Your Honor.
Yes, Your Honor.
Ms. Bond, what did you learn from the defendant's email?
Well, the defendant knew that she was the sole heir to the entirety of Miss Lee's estate.
Were you at the reading of Miss Lee's will?
Yes, I, along with the defendant, Ms. Rogers, and Ms. Cabrera, were present on the day Miss Lee's lawyer announced who would be the heir to her fortune.
What happened at that reading?
When Miss Lee's lawyer proclaimed the heir was the defendant repeated over and over, "I can't believe it. I had no idea." Wrong? Her emails proved that much. Enemies of the heir, beware.
Were there any pieces of forensic evidence collected from Lee Manor?
Yes, fingerprints. One was collected off a black bag found in the defendant's closet. 2 others were collected off the good pills stored in Miss Lee's bathroom.
I'm showing you what has been marked as Exhibit 15. What is it?
Well, that's the black bag I was just speaking about, the one found in the defendant's closet.
Does it appear to be the same as the last time that you saw it?
Yes.
Um,
At this time, the plaintiff offers Exhibit 15.
Any objection?
Yes, Your Honor, to lack of foundation, if I may.
You may.
Well, they have said that this black bag was found in Drew Marr's wardrobe. We have no idea of how a search was conducted, who it was found by, or any of the circumstances surrounding the search itself. And I believe that foundation for that needs to be laid for the jury to understand this exhibit.
Do you have a response, counsel?
Your Honor, this line of questioning is following an investigation that was conducted by Ms. Bond and Detective Kahn, and this back bag was found by the police during that investigation, which Ms. Bond was allowed to tag along during.
And that is the exact foundation I would like to be laid, Your Honor.
I tend to agree with Mr. Dubsky. I would ask that you lay more foundation as to how this bag was retrieved before we consider entering it into evidence.
Yes, Your Honor.
Yes, Your Honor.
Ms. Bond, who found the black bag in the defendant's closet?
Detective Kahn.
And at what point during the investigation was it found?
Later on in the investigation. It wasn't the first day that I'd arrived. I believed it was a couple days after.
At this time, Your Honor, we would offer Exhibit 15.
Objection at this point?
Yes, I still believe foundation has not been laid. A couple days later, I do not believe is sufficient foundation for the jury to understand exactly how this investigative process went.
I'm going to sustain the objection. I'd ask that you be a bit more specific about when this bag was retrieved. Also, if she was present and saw this, or how she knows the circumstances from which it was retrieved. Otherwise, I'd ask you to move on.
Yes, Your Honor. Ms. Bond, are you aware what day it was that this bag was found during the police investigation?
Well, I don't remember the specific date. All I remember is that Detective Kahn had to ensure that before searching the house, she needed to go back and get a warrant. So when she arrived back to the manor with her warrant, she was able to go through the house. At that point, she was able to look through Drew's room, and she found that this black bag was in the defendant's closet. Now, I have been able to review Detective Kahn's police report in its entirety, and I also found that there as well.
Your Honor, at this time, the plaintiff would offer Exhibit 15.
Any objections?
Again, they still haven't been able to lay that foundation. I believe that that knowledge exists. However, until that knowledge has been elicited, there is still no sufficient foundation for this exhibit.
I'm going to admit it at this point. I think the jury has enough context to understand what this exhibit is and understand what opposing counsel is going to be using it for. So,
yes, Your Honor.
Yes, Your Honor. Ms. Bond, what did you learn from this black bag?
Inside the bag was a pill container filled with the bad pills. A fingerprint analysis showed that the defendant had touched its zipper.
You mentioned earlier that 2 fingerprints were collected off of the good pills found in Miss Lee's bathroom. Whose fingerprints were those?
Yes. This helped me to answer the real mystery at the time. You see, the good pills she would have taken each night were stored in a pill organizer by her bedside. I saw that for myself the first day I arrived at the manor. But if her good pills for the night had been switched with the bad pills, where then were the good pills?
Objection, Your Honor. Again to speculation.
Response?
Yes, Your Honor. The witness has already testified that Miss Lee's pill organizer was found on her bedside table. And through her investigation, she discovered there were a certain amount of pills that Miss Lee was supposed to have taken each night. And she has also testified that the prescription arthritis medication, as well as the over-the-counter heartburn medication, appeared physically identical. Now, this is simply based off of her rationally based perceptions in concluding that because Miss Lee had chloroandramine in her system and did not have her prescription arthritis medicine that night, that the pills had been switched. So the witness is simply testifying to what she had discovered.
I'm going to overrule you.
Yes, Your Honor.
Miss Bond, what were you saying about those good pills?
Well, if her good pills for the night had been switched with those bad pills, where then were the good pills? Well, those two good pills, having been taken out of Miss Lee's pill box and put back into the bottle, had the defendant's fingerprints on them. The proof was on the pills.
Thank you, Miss Bond. I have no further questions, Your Honor.
All right, defense ready for cross?
Yes, Your Honor. Now, good afternoon, Miss Bond. I'm Andrew Dubsky, and on behalf of the defendant, Drew Mars, I will be asking you a few questions this afternoon.
All right, good afternoon.
Now, Miss Bond, you were first retained by Miss Rogers on June 5th of 2018, correct?
Yes, that was the case of the missing grandmother.
And Miss Rogers retained your services exactly to find their grandmother, right?
Yes, she called me saying that she wanted to locate her grandmother, and I said I could do just that.
And at first you wanted to decline this case, didn't you?
The missing grandmother?
That's correct.
Well, at first I didn't know that the missing grandmother had been a famous author, Miss Agatha Lee. But after I learned that, I was all right with helping.
Well, to bring you back a bit, to answer my question, you did want to first decline the case, correct?
At first, I didn't quite understand what was going on. I thought a simple Google search could solve the problem.
So that's a yes to my question?
Yes, at first.
All right. And like you just said, the only reason you decided to take up the case was because you found out the grandmother was Agatha Lee, who was famous, correct?
Well, that wasn't the only reason. I was leaning towards declining to take the case. However, when I realized that Miss Lee was a famous author, that did help me to decide whether or not I did want to spend my time looking for the grandmother.
Okay, so you provided Agatha Lee's address to Miss Rogers on June 7th, correct? After you took the case?
Yes.
And that means you found Agatha Lee's address in under 2 days, didn't you?
Yes.
And so for that less than 48 hours of work, you were paid $10,000, weren't you?
Yes, I was. I don't necessarily have a standard rate. I usually leave it up to my clients to pay me however much they want to. And they decided that $10,000 was enough.
Now, Miss Bond, are you aware that Miss Rogers had only $2,000 to their name after they paid you for their services the first time?
No, I knew nothing about that. I don't tend to ask my clients about how much money they have in the bank.
All right, but isn't it true that Miss Rogers has promised to pay you $25,000 for your services in this case only 2 months after they paid you the first time?
Yes, for my work in trying to see if there was any foul play in Miss Lee's death. The Ms. Rogers said that she could pay me for that.
Okay, so she said she could pay you for that, but are you aware that only by winning this case would Miss Rogers inherit almost $20 million in cash?
By winning this case? Well, I'm not quite certain of the law. I do know that there is a will, and that Miss Lee's will is worth $20 million. But I'm not quite sure what would happen to that will if Ms. Rogers were to win this case.
Okay. Now, Ms. Rogers, Ms. Bond, excuse me, directing you back to the second time your services were requested. That was August 15th of 2018, correct?
Yes.
And Ms. Rogers hired you again to investigate the murder of her grandmother, didn't they?
Yes, she called me to say that her grandmother had been murdered, so obviously I came over as fast as I could.
And to clarify, this was the same grandmother that you helped Ms. Rogers locate not 2 months before?
Yes.
And you arrived to Lee Manor less than an hour after Ms. Rogers contacted you, didn't you?
Yes, like I said, Ms. Rogers claimed that her grandmother had been murdered, so as soon as possible.
Okay, and when you spoke to Miss Rogers, she believes that Drew Mars murdered her grandmother, didn't she?
Yes, she had her suspicions, and she suspected that Drew Mars had something to do with her grandmother's murder. However, we didn't point any fingers until we had collected enough evidence to make a decision on who did what.
Miss Bond, is it your testimony today that your first interaction with Miss Rogers that day did not lead to her accusing Drew Mars of her grandmother's murder?
I'm confused by your question. I did say that Ms. Rogers had her suspicions, and she made me aware of those suspicions. However, I, as an investigator, didn't point any fingers until the evidence was collected. Then I could make a decision.
So to clarify, Miss Rogers did have her suspicions, correct?
Yes.
And this was before an investigation was launched?
Yes.
All right. Now, isn't it true that, just to clarify, that Miss Rogers is the one who is hiring you for this investigation, correct?
Yes, she's the one who called me to the manor.
And they're the one pointing the finger at Drew Mars, right?
Yes.
Now, later that morning on August 15th, you spoke to Drew Mars, didn't you?
Yes, I did.
And you're aware that they were Agatha Lee's live-in caretaker?
This is correct.
So you're aware that they possessed a bedroom on the second floor of Lee Manor, right?
Yes, we searched that bedroom.
And it was during this conversation with Mr. Mars that you asked them to look around their room?
Yes.
But your request was denied, wasn't it, Miss Bond?
Yes.
So Drew Mars explicitly refused your request to search their room?
Yes.
Now, Miss Bond, you entered and searched through Drew's room that morning anyways, didn't you?
I did.
And now, yes or no, Miss Bond, no one ever gave you permission to conduct this search, did they?
I'm confused by your question. Gave me permission to do the search? I was already searching the manor, and then I decided to search Drew's room.
Exactly, but you received no permission, correct?
No, Drew said that he didn't want me to search the room, and that led me to be suspicious.
All right. However, did you ever, excuse me, Your Honor. Now, Miss Bond, you conducted this search before you even asked Drew Mars for permission, didn't you?
I don't quite remember. I just know that I did in fact search their room.
So, Miss Bond, is your testimony today that you don't know if you searched Drew Mars's room before or after you spoke to them that day?
Yes, this was almost 2 years ago. Could you refresh my memory?
Of course. Your Honor, permission to share my screen with a copy of M. Bond's proclamation?
Objection, Your Honor, to 403. It would be substantially more prejudicial to the jury to screen share Ms. Bond's affidavit for the purposes of impeachment. Opposing counsel can do that without sharing the affidavit onto the screen.
Let me clarify, are you planning on refreshing her memory with her affidavit? Would it be sufficient for you to constructively do that out of the earshot and sight of the jury?
Your Honor, I believe that it's extremely probative for the jury to see this pronouncement of M. Bond as it attacks specifically their credibility as a witness.
Your Honor, if I may respond.
May.
During opening ceremonies, it was stated that it is not allowed and that opposing counsel should assume that the witness has the pronouncement in front of them. Therefore, this will substantially prejudice the jury, and opposing counsel should do this without sharing the screen.
You have a response to that, Counselor?
Yes, Your Honor. I'm simply refreshing the recollection of this witness, specifically as if they were to have their affidavit or the document constructively used as their affidavit, they should have access to this information and therefore be able to accurately answer my question. And due to that inability to do so, I believe it's extremely important to refresh the recollection in the eyes of the jury.
What I'm going to do is I'm going to allow you to share your screen, but I am going to constructively make this out of the sight and earshot of the jury. That way we have context for what you're doing, but I agree with plaintiff counsel, and we're not going to allow the jury to see this. However,
yes, Your Honor.
You share it. With that, objection sustained.
Yes, Your Honor. Now, Ms. Bond, can you see my screen here?
Yes, I can.
Now, on line, one moment, Your Honor. On line 79, 78 through 80 is when you say you decided to stretch your legs, correct?
Yes.
Now, later on line 95, you later speak to Mars, correct?
Yes.
And one moment. Yeah, and on line 114 through 116, you asked them to search their room, correct?
I'm sorry, could you repeat that one more time? I didn't hear you.
On line 114 through 116, you decided to ask Drew Mars to search their room, correct?
Yes.
Now, on line 190, at the end of your affidavit, you admit that you searched Drew Mars's room, correct?
Yes, as I said before, I did in fact search the defendant's room.
And you said so that you decided to while you were stretching your legs, correct?
Yes.
So, Miss Bond, yes or no, did you search Drew Mars's room before you even asked them for permission?
Oh, now that my memory has been refreshed. No, I didn't ask before searching the room.
Thank you, Your Honor.
And then when I asked, he said no. That also led me to be suspicious.
All right. Now, one last question, Miss Bond. How many fingerprints did you find on the pill bottle that you found in Drew Mars's room?
There were fingerprints, but we couldn't get a match. There weren't. They were too smudgy.
Exactly. So there were no conclusive fingerprint matches from Drew Mars, correct?
No, Drew Mars's fingerprints were only on the bag.
So to answer my question, they were not on the pill case, correct?
No.
Thank you, Your Honor. No further questions.
Not that I could tell anyway. Too much.
Any redirect?
No, Your Honor, but at this time, the plaintiff would ask to be able to read evidentiary ruling 13 onto the record.
Any objection?
Allow me to find that evidentiary ruling. No objection, Your Honor.
Go right ahead.
13. The court has considered and overruled all constitutional objections, including but not limited to those regarding Exhibit 13 and Bond's search of Mars's bedroom on August 15th, 2018. At this time, Your Honor, the plaintiff rests with this witness.
Great, you may be excused, Ms. Bond. And with that, feel free to call your next witness.
Yes, Your Honor. Prior to calling our next witness, I would just like to clear up an issue that we seem to have had in the last examination. Now, in opening ceremonies, the question was asked if teams could do exactly what opposing counsel just did with the affidavit. The representative for the tournament stated that no, we are by no means allowed to do that because in live trial, you would never give the judge or jury a copy of the affidavit. Instead, the witnesses are all instructed to have their statements in front of them on their computer. And if an attorney would like to proceed with impeachment, they can ask the witness to focus on their own copy. We just don't want affidavits to be shown the rest of trial.
Okay, with that, we will take note of that and no longer allow attorneys to show affidavits. My apologies, we weren't informed of that during judges.
That's okay, Your Honor. I thought so. That's why I wanted to bring it to your attention.
Thank you. And with that, feel free to start your direct whenever you're ready.
Yes, Your Honor. The plaintiff would like to call Stevie Rogers to the stand. Please state your name for the record.
My name is Stevie Rogers.
Do you live here in Midlands?
Yes, Midlands has been my home since I moved here in 2018 to be with my Nana.
I'd like to talk to you about your grandma, Agatha Lee. What was your relationship like with her?
When I was growing up, she was my best friend. We were almost inseparable, but things changed after my parents died.
How did your relationship change after the death of your parents?
Well, I took off. I traveled. I still loved my Nana, but spending time with her after my parents passed was a constant reminder of what I lost. The pain was unbearable, but 2018 was the 10-year anniversary of their death, and I needed to be with my Nana.
Miss Rogers, were you able to be with her?
Yes. When I moved in with Nana, I felt like I was home again. Dealing with my parents passing suddenly wasn't so difficult. That's what made her death that much harder.
Miss Rogers, I know this is going to be difficult, so if at any time you need to take a break, feel free to let me know, okay?
Okay.
Now, I'd like to ask you about your grandmother's medication. When you were with your grandma, did you ever handle her medication?
No. Before Nana's heart attack in 2008, she took care of it herself. Then, after her heart attack, she hired a caregiver who managed it. Honestly,
Objection to speculation.
You have a response?
I would ask opposing counsel to clarify what statement is speculation.
The handling of Miss Agatha's, I'm sorry if I may respond, Your Honor.
Okay, please clarify.
The handling of medication by other parties other than Miss Stevie Rogers herself to claim that she has knowledge of who handled her medication while she was not in the house and would have no knowledge of it besides her, beyond her senses, calls for speculation and is speculative in statements.
May I respond? Your Honor, we've already established throughout trial today that Miss Lee did have a caretaker, and this witness testified that after her parents died, her Nana had a heart attack, and that's when she had to hire a caretaker. Now, this is within this witness's rationally based perception that if her grandmother hired a caretaker in order to recover from a heart attack, that this caretaker would be handling her medication.
Ms. Mostro, do you have a response to that?
Simply because we know that Ms. Agatha Lee had a caretaker, we have not heard nor lay foundation to prove that this particular witness knows of the exact duties of that caretaker. We don't know of the particular duties of that caretaker, so nor could Ms. Stevens, only that Drew Mars was the caretaker.
May I respond?
Final response.
Your Honor, this witness testified that her grandmother had a heart attack and hired a caretaker because she was unable to care for herself. She needed to have a live-in nurse with her all the time. I think it's safe for this witness to testify that to her rationally based perceptions that if her grandmother could not take care of herself, somebody else would be giving her medication.
I'm going to overrule the objection for now. I think that this does fall within the witness's rationally based perceptions. However, if we get into specifics and there isn't any foundation to understand how she has the personal knowledge to testify to that, feel free to re-raise your objection.
Yes, Your Honor.
Ms. Rogers, can you finish what you were saying about whether or not you ever handled your grandmother's medication?
Sure. Like I was saying, Nana took care of herself before the heart attack, but afterwards she had a caregiver who took care of it. I honestly don't even know the medications my Nana took.
I'd like to fast forward to August 14th. Did you talk to Miss Lee on that day?
Of course. I spent time with her every day. And on the 14th, we actually talked about her will.
Had you discussed the will before this?
No, but I had seen it after my parents died. Since I was the only family she had left, she was leaving her estate to me.
Did that ever change?
Yes. At some point, I found out that I was removed from the will and that her caretaker had replaced me.
Well, Ms. Rogers, how did that make you feel?
I'll be honest, it hurt, but it wasn't anyone's fault but my own. I respected my Nana's decision. I didn't need to be in her will. I just wanted to be in her life.
And Ms. Rogers, when you say her caretaker, are you referring to the defendant, Drew Mars?
Yes, I am.
Now let's return back to the 14th. You said that you talked about the will. Do you remember the specifics you discussed?
Yes. Nana said that she was putting me back in the will. She told me she loved me and she was glad we were together again. She said she was going to leave her estate to me. I was shocked. I didn't expect it.
Do you know if Miss Lee told the defendant the same information?
She didn't have to. When we opened the door, Drew was standing right outside. He jumped back like he had his ear to the door.
Well, did the defendant do anything?
Objection, Your Honor, to speculation.
May I respond? Your Honor, the next question I'm going to ask this witness is, did the defendant do anything that indicated to you that that they had actually heard the conversation? And I believe that will clear up any issue of speculation that we have. If we could, for the time being, allow that to stand, and if counsel still feels that the witness is speculating after their next answer, I'd be more than willing to argue that.
Let's do that. Let's hear the response to the next question. And if you still have your objection, feel free to re-raise it at that time.
Yes, Your Honor, I'm amenable to that.
Ms. Mars, did the defendant do anything that indicated to you that he had actually heard the conversation?
Yes. Right after Nana and I left the room, he mouthed, "No way" to me. His face was red, his eyes were squinty, his fists were clenched. He obviously wasn't happy.
Ms. Rogers, when was the next time you saw Miss Lee that day?
When she got home from lunch. We watched a couple of movies and then we had dinner in her study. I said goodnight to her at about 9:30 p.m. I wish I'd known that those were going to be the last moments I'd have with her.
Did you see anybody else after you said goodnight to Miss Lee?
Yes. About 5 minutes later, I saw Drew tiptoeing to Nana's bedroom.
What was the defendant doing when you saw when you saw him tiptoeing toward Miss Lee's bedroom?
Drew had his right arm raised with a fist closed. It looked like he was carrying something, but I couldn't see what it was.
Was the defendant the last person you saw that day before Miss Lee died?
Yes. The last thing I saw before waking up to the news that my Nana was gone was Drew going to her room that night.
Thank you, Ms. Rogers. I have no further questions at this time.
Thank you. And with that, cross-examination for the defense?
Yes, Your Honor. Now, Ms. Rogers, I'm going to be asking you a series of yes or no questions. And if at any point you feel you're unable to answer these questions, let me know and I'll rephrase, all right?
Okay.
Now, you and your grandmother had spent a great deal of time apart, haven't you two?
We did. It was about 8 years apart. I would give anything to go change that.
And yet, despite being separated for 8 years, the distance between Monroe, Alabama and Europe, she still reached out to you, didn't she?
Yes, she would send me letters pretty frequently.
She left you multiple messages on your phone?
She left me a few.
And yet, in the 8 years you were gone, you called her only once before showing up at Lee Manor, is that correct?
Yes, I regret it more than anything.
Regardless if you regret it, that is true, correct?
Yes, I only called her one time.
And you never sent her a single letter in those 8 years apart?
No, somehow I just couldn't find the words to tell her what was going on with me and how much I missed her.
And yet, like you were saying, you finally did reconnect with her. You didn't know where she lived, did you?
No, I went back to the house in Alabama, but it had been destroyed, and I didn't know where my Nana was at that point.
So in that one conversation you had with your grandmother in those 8 years, you never decided to talk to your elderly grandmother about her living situation?
I honestly,
Your Honor, to relevance, may I be heard?
Yeah.
Now, whether or not this witness ever had a fleeting thought about whether or not to call her elderly grandmother makes no fact in today's case more or less likely. Now, counsel is welcome to ask if she ever did call her grandmother, like she has. However, to ask this witness, have you never thought to call your grandmother? Not only is it not relevant, but it's very unlikely that the witness can remember every single thought she's had over the last 2 years, or over that 8-year span, rather.
I'm going to overrule the objection for now. If they go down this rabbit hole further and really ask a lot of questions about it, feel free to re-raise, but I think right now we're fine.
I'm sorry, I don't believe I got your response, Miss Rogers. Did you ever ask your grandmother about her living situation?
no, I guess I just assumed she was at the manor in Alabama.
So now that it's established that you did not know, you had to hire M. Bond to find her. Is that correct?
Yes, I knew I couldn't do it on my own. My Nana had always lived under the radar, so it was something I was going to need help with.
Yet you were not employed at the time of contacting Ms. Bond. Is that correct?
That's correct. I didn't have a job at that point.
That's right. You only had $12,000 to your name. Is that correct?
Yes, that's what was left over from my trust fund.
Yet you paid $10,000 to Miss Bond to find your Nana, didn't you?
Objection, Your Honor, to relevance. May I be heard?
You may.
Now, we've already established how much money this witness had in her account, and we've established how much she was going to pay, we've established how much money she had in her account. However, the amount of money that she used of that to pay the detective makes no fact more or less likely. I mean, this witness can testify, or this counsel can ask this witness to testify about the amount of money she had and if she hired Detective Bond, but to actually ask how much she paid Detective Bond out of the amount of money that was left in her trust fund makes no fact more or less likely.
I'm going to overrule for now.
Thank you, Your Honor. Now, I don't believe I quite got that answer. You had paid Bond $10,000 to find your Nana, is that correct?
Yes, I would do anything for my Nana, even if it meant using almost all the money that I had left.
And yet you were planning on surviving off of the remaining $2,000 with no steady job, weren't you?
If I couldn't find my Nana, if I couldn't get a job, if I couldn't sell things, then yes.
Now, I'd like to focus your attention to August 14th, 2018. You had been drinking that night, correct?
I had a couple glasses of brandy over a few hours, if that's what you're asking.
That is what I'm asking. Is that yes to my question?
Yes, a couple glasses of brandy over a few hours.
Objection, Your Honor. Under 403, more prejudicial than probative. May I be heard?
Sorry,
Oh, I'm sorry, I didn't catch that. Your Honor, I have a good faith basis that this line of questioning is for the purpose of insinuating that Miss Mars may have been somewhat intoxicated on the night that she claimed to have seen the defendant, or that she said the defendant was going towards her grandmother's bedroom. Now, every person in this world metabolizes alcohol at a different rate, and we have absolutely no evidence to suggest anything about how Miss Rogers would have been affected by any amount of alcohol. If this questioning is allowed, it will inflame the passions of the jury to weigh this testimony based on how 2 or 3 glasses of brandy would affect them. And for that reason, it can't be allowed in court today.
Your Honor, if I may be heard.
Sure, very briefly.
I'm not trying to bring this evidence up in terms of how it may have affected Miss Rogers, but rather the credibility of the witness, if I may be allowed to continue. I have no plans on asking how the alcohol had affected her that night, simply that she was drinking.
May I respond?
No response. I'm going to overrule the objection. I think that this goes to weight, not admissibility. Feel free to bring it up on redirect if you want to delve into specifics about how she might have been affected or might not have been affected, but right now I'm going to overrule.
Now, Miss Rogers, you were drinking that night, yet didn't you tell your grandmother that you had stopped drinking?
Yes, I did. I was trying to stop. I had cut down substantially, but she didn't like when I drank at home, so I didn't tell her.
And yet, we have established that you were indeed drinking, correct?
Objection, Your Honor. At this point, I believe the testimony has crossed the line into more prejudicial than probative. We're no longer just talking about Miss Rogers' actions on that night, but now we're bringing in whether or not her grandma knew she was drinking and all these other factors, when in reality, yes, Miss Rogers told her grandmother that she stopped drinking, but we have no way of believing if Miss Lee actually believed that she wasn't drinking.
I'm going to sustain the objection. The testimony about whether her grandmother knew that she was drinking. You're welcome to delve into the fact that she was drinking and to attack her credibility onto what we heard during direct examination about what she might have seen that night. But going into the relationship with her grandmother and her knowledge about her drinking, I think that crosses the line.
Your Honor, I'm sorry, you cut out a little bit on my end. Did you strike that testimony already?
Yes, it's stricken.
Thank you.
All right, Miss Roger. Now, moving on, after you had talked to Miss Lee with both her and Drew Mars, they had left to go to a biography meeting that afternoon. Is that correct?
Yes, my Nana was getting lunch and Drew was driving her there and bringing her back home.
And they were gone for a while, weren't they?
A couple of hours, give or take.
All right, and I would be correct in saying that there aren't any locks inside the house, wouldn't I?
No, that's not correct.
Oh, then where do you, excuse me. Then you must be aware that there is a lock on your Nana's main bedroom door, is that correct?
Yes, there is a lock on Nana's door, but I'm not quite sure if there are other locks and other rooms that weren't my own.
There isn't a door on Drew Mars's bedroom, right?
No, there's a door on his bedroom.
I'm sorry, a lock on his door.
I'm not sure.
And there isn't a lock in the bathroom adjacent to Miss Lee's bedroom, is there?
I'm not sure.
So, assuming that there wasn't a lock on either of these rooms, and Mr. Mars wasn't in his room,
Objection,
anyone
Your
could go in there. Is that correct?
Objection, Your Honor, to argumentative. Now, this witness just said that she's not sure if there are any locks, and then counsel asked the witness to assume that there weren't locks and then speculate about what may have been able to happen if there, in fact, were no locks.
Your response?
Your Honor, I'm simply asking whether it would be possible if this witness, without their knowledge of there being locks or not, to enter into any of the rooms on August 14th.
Your Honor, that's... Go ahead.
Whether they had access to any of the rooms, they're more than happy to testify to that.
May I respond?
You may file a response.
Your Honor, this witness can testify to that, but that was not the question that was posed. The question asked her to assume and then speculate.
I'm going to agree and ask you to rephrase the question. Right now,
So you don't know if there are any locks leading to the restroom,
Not sure, like I said.
and you don't know if there is a lock leading to Mars's bedroom. Is that correct? So could you, excuse me, so could you have gone to any of these rooms while Miss Lee and Drew Mars was out?
I don't know. I didn't try to get into any of the rooms while they were gone, so I don't know if they were locked or not.
Whether or not they were locked, could you have gotten into any of these rooms at the time?
Objection, Your Honor. This witness is being asked to speculate, and in addition to that, this has been asked and answered. The witness has clearly stated she doesn't know because she didn't try.
I'm going to agree and sustain the objection.
Motion to strike the last answer the witness gave, or I believe she did not start giving an answer. Never mind.
I think you're correct.
Your Honor, may I respond to that objection?
I think that I'm going to sustain the objection. If you want to rephrase, go ahead, but I think that you've made your point, and I would advise you to move on.
Then I have no more questions, Your Honor.
Thank you. Do you have a redirect?
No redirect, Your Honor.
Okay, with that, Ms. Rogers, you're welcome to step down. And now we have, I guess I would ask the bailiff if we have time for a 5-minute break or whether we should just keep going.
So, all us is going to be in an hour and 2 minutes. So, kind of depending on what defense thinks they need for their case in chief, I'd probably advise us to try and shorten the break a little bit. But, if y'all think y'all are going to have a really short case in chief, that's also fine.
Do you have any, do you have any thoughts on that, defense?
I'm not too sure as to how long it'll take with the crosses as well, but we're amenable to taking a shorter break, I think.
Okay, with that, let's take a 3-minute break. We'll come back at 4:15 Eastern Standard Time. And then just to advise the judges that, remember, we are being broadcast live on YouTube. And just keep that in mind with what you decide to do over break.
Yes, Your Honor.
Okay. I'm going to go ahead and put all of the teams back into their breakout rooms, and then judges will just stay in this room. Judges, as you come back, please just drop me a message in chat that you're back and that you're back at your computer. Okay, so it looks like I've heard from all of the judges except Jessica that everybody's back. Jessica, are you here?
Oh, yeah, sorry.
Okay, perfect. So it looks like everybody's back. I'm going to go ahead and bring the students back in. So they all will be back here in the next 60 seconds, and y'all are free to proceed whenever you're ready.
Great. Defense, feel free to call your first witness whenever you're ready. Did we lose defense counsel?
At this time, the defense calls Drew Mars to the stand.
Good afternoon, Your Honor.
Good afternoon. Would you please state your name for the record?
My full name is Andrew Lloyd Mars, but most people just call me Drew.
All right, Drew. What do you do for a living?
Well, right now I'm just picking up a few babysitting shifts whenever I can just to make ends meet and send some money back home to my family. But I've really only had one job.
And what job was that?
I was the caretaker for Agatha Lee.
Were you Mrs. Only caretaker?
Actually, for about a year and a half, I worked as the assistant caretaker to Agatha while I was still in college. But sometime in the summer of 2009, the head caretaker, Hunter, just disappeared for some reason. So Agatha decided to hire me full time. And from there, I worked with Agatha as her only caretaker. We became close friends.
Would you please describe your relationship to Miss Lee?
Of course, Agatha was always technically my boss, but she was really more like the Nana that I got to choose. We weren't family in name, but we were so much more. As her live-in caretaker, I lived with her for about a decade, actually. We often watched movies together, we read together, but we really became friends over the backgammon board. She always told me, "You young man are quite the bright mind. 40 years of playing and you're the only one who could beat me."
Objection, Your Honor, to hearsay as to the statements from Agatha Lee, and also to narrative, as I believe that once the witness started with the statement, it no longer was answering the question posed.
Your Honor, may I respond? We're not trying to offer this testimony for the truth of the matter. It does not matter whether Mr. Drew Mars was actually good at backgammon. It is simply to highlight the relationship that he had with Miss Lee. And on counselor's grounds of narrative, that was the last sentence that he said, that 40 years of playing backgammon and that he was the only person that could beat her was the last sentence in that response, I believe.
I'm going to overrule the objection.
Now, Mr. Mars, what was your responsibilities as Miss Lee's caretaker?
I really helped Agatha with anything that she needed. She did a lot by herself, but whenever she didn't want to, I did her shopping, her cooking, her cleaning for her. I drove her around to some weekly biography appointments, and I made sure that I filled her pills every Saturday.
Now, what kind of pill did Miss Lee have to take?
Every night, Agatha took an 81 milligram pill of aspirin for her heart problems, a 500 milligram pill of vitamin B, and 250 milligram Winterin pills for her arthritis.
To your knowledge, do you know if Miss Lee had any allergies?
Yes, she had an allergy to a heartburn medication, chloroandramine.
Are you aware that Miss Lee died from an allergic reaction to chloroandramine?
Objection, Your Honor, leading.
Your response?
Your Honor, this question does not strictly call for a yes or no answer. The witness is able to answer it however he may choose, whether that is a yes or a no or anything in between.
May I respond?
I'm simply asking you the knowledge of how she died.
Whoops. I'm going to overrule the objection.
Now, I don't believe I got a response. Do you know how? Sorry, continue.
Yes, I'm aware that she died of an allergic reaction to chloroandramine.
Mr. Mars, have you ever purchased chloroandramine?
No, I have never purchased chloroandramine. There was never any reason to.
To the best of your knowledge, was there anybody in the house that day that could have purchased chloroandramine?
Objection, Your Honor, to speculation. May I be heard?
May I respond?
Asking.
Let's hear from plaintiff counsel first about the grounds for her objection.
Yes, Your Honor.
Your Honor, asking this witness, even just putting the words "to your knowledge" in front of it doesn't mean that this doesn't make a question non-speculative. To ask a witness to your knowledge, could anybody have done XYZ is speculation, because this witness would have, we've heard no foundation that this witness would have any way of knowing we've heard no foundation as to how this witness would know how they could or could not have done something.
Your Honor, may I respond?
You may.
I'm simply asking not if anybody did purchase chloroandramine in the house, but whether somebody had the ability to purchase chloroandramine that was residing in the house that day. I'm not asking them to speculate the actions of another, but what would be possible.
May I respond?
I'm going to overrule the objection for now. I think the jury can make that distinction. However, if they go further into speculating what person might have been able to do, feel free to re-raise.
Yes, Your Honor. Now, I don't believe I got your response. Is there anyone else in the house that could have purchased chloroandramine?
I honestly don't know if anyone did, but it's a easy to access over-the-counter drug, so anybody could have purchased it, and the only other person at the house at that day was Stevie Rogers.
Now, how do you know Miss Rogers?
Miss Rogers was Agatha's only grandchild, and she came to live with us in around July of 2018. Despite living with Agatha for over a decade, I had actually never met them until that day. But Agatha spoke of them often.
Were they living in the house with you on August 14th?
Yeah, it was about a month by then.
To your perception, how is Miss Lee's relationship with her grandchild?
Honestly, it was okay at best. After Agatha's daughter, Veronica, passed away, Miss Rogers just disappeared from Agatha's life, only contacting her for more spending money or asking to pay Miss Rogers' tuition for law school until they dropped out.
Objection, Your Honor, lack of foundation. May I be heard?
Yeah.
Now, this witness is, this witness is able to testify to these facts if counsel can lay some foundation as to how this witness knows these facts. This witness is saying that that he knows things like they never talked, he never wrote, and things of that nature, when it's very possible that Miss Lee did have private conversations without the knowledge of Mr. Mars.
Your Honor, may I be heard?
Briefly.
Because Mr. Mars was not sequestered during this entire trial, they have the knowledge of not only when Stevie called, from the words of Stevie herself, but also from words of Bond and other witnesses that can have testified and have in court statements that you heard here today about the contact between Miss Rogers and grandmother.
At this time, I'm going to sustain the objection in that you can't ask him sort of generalities about the relationship between these two individuals. You can ask him specifics about what he knew in terms of their relationship, but let's stay away from generalities and talk about his knowledge.
Motion to strike.
Yes, Your Honor.
Is the last answer?
Yes.
Now, to your knowledge, did Miss Lee ever try to reach out to Miss Rogers?
She did all the time. She called and left messages and even showed me some letters that she wrote to Miss Rogers. But to my knowledge, Miss Rogers never responded.
Would you recognize one of these letters if I were to show it to you?
Yes, I'm sure I would.
At this time, I am presenting what is previously marked as Exhibit 10. Now, Mr. Drew, is this a fair and accurate copy of the letter that Miss Lee showed you?
Yes, it appears to be one.
And in general, what is this letter about?
It's a letter from Agatha to Miss Rogers, explaining her decision to take Miss Rogers out of the will.
And when is this letter dated?
On February 1st of 2018.
At this time, the defense would now like to admit Exhibit 10 into evidence.
Any objections?
Yes, Your Honor. Now, there are statements within this document. My objection is to hearsay. There are statements within this document that are made by Agatha Lee that are statements of intent, which would fall under the exception 8033. However, any other part of this letter must be constructively redacted in order for it to be admissible.
Your Honor, may I be heard?
You may.
The defense is amenable to redacting parts of the letter. However, we would still inquire and still admit into evidence the last two paragraphs of the letter, the date, and Miss Lee's signature. However, the first three paragraphs were amenable to redacting.
May I respond?
Yes.
Your Honor, actually, I believe that the only sentence that needs to be admitted into evidence for counsel to get their point across is at the bottom, the last sentence in the fourth paragraph. So just as soon as I sign this letter, I'm going to sign a new will, leaving everything to Drew. Now, that statement is Miss Lee's statement of intent that falls under the exception to hearsay. With that there, everything else can be constructively redacted because that's the only truth that the plaintiff or that the defense is attempting to get out of this.
Would you agree with that?
In part, I do agree that the last sentence of the fourth paragraph, it does follow under Rule 803. However, I would also include under 803 the first sentence of the fourth paragraph. Because we've become family name only, I've decided to change my will. Because of that first part of the sentence, it then leads into the 803 exception that my opposing counsel has just mentioned. And as I had said before, besides that first and last sentence, we're amenable to redacting.
Okay, so for the sake of time, let's redact minus the first and last sentence, the date, the signature. And with
Yes.
that, Exhibit 10.
Thank you, Your Honor. Now, Mr. Mars, I realize there's a lot of this letter that has been redacted, but would you be able to read the part of the letter that has not been redacted?
Of course. February 1st, 2018, Stevie. Because we become family in name only, I've decided to change my will. So just as soon as I sign this letter, I'm going to sign a new will, leaving everything to Drew. Love, Nana Agatha.
Thank you. I'm now taking Exhibit 10 off of the screen. Now, Mr. Mars, did the topic of Miss Lee's will ever come up again?
Yeah, there was a conversation about it between Agatha and Miss Rogers.
And when was that?
It was on August 14th of 2018.
Where were you at the time?
I had just made 2 cups of tea for Agatha and Miss Rogers. Earl Grey with 4 tablespoons of honey. That's how Agatha took it. I used to always joke that she should drink more tea with her honey.
Objection, Your Honor, to narrative and motion to strike. That answer is non-responsive. The question was, where were you? And the witness didn't even answer the question.
I'm going to overrule the objection.
Your Honor. Thank you, Your Honor. Now, how do you know that this conversation was taking place on August 14th?
Well, I was bringing the tea up to Agatha's study when I heard them.
And what did you hear happening?
Agatha told Miss Rogers that she was not going to change her will.
And how did you hear Miss Rogers respond?
Well,
I'm sorry, did you hear Miss Rogers respond?
I kind of did. I heard Miss Rogers try to speak up a little, but barely anything came out. I don't remember exactly what she said. Then I heard Agatha coming back towards the door.
Able to see how Miss Rogers looked?
Yeah, she seemed disappointed and then angry when they saw me. She was scowling and glared at me.
Did you see Miss Lee again that day?
Yes, I did. I drove her to an appointment at a local cafe and then eventually back home.
Now, Mr. Drew, did you return home at any point without Miss Lee?
No, after I dropped her off, I went to the pharmacy to pick up some toiletries for my upcoming tender date, and then I went back to pick Agatha up.
How long were you and Miss Lee gone for?
It was about 2.5 hours, I'd say.
To the best of your knowledge, do you know if there was anyone else at Lee Manor when you two had left?
It was just Stevie. They were at the study when we left.
To your knowledge, what did Miss Lee do once you got home?
She took a nap until dinner, but she locked her door, which she almost never does. She used to always say that the only lock that really mattered was John Locke. And then later on, I served Miss Rogers and her orange scones with clotted cream at around 6:30, but then I didn't see her again after that.
Did you see Miss Rogers with her that day?
Sorry, could you repeat that question?
Did you see Miss Rogers later that day?
I did. I saw them in the sitting area next to all the bedrooms upstairs, drinking what seemed to be wine, but the bottle was empty at that point. I also saw Miss Rogers and Agatha's study when I was serving dinner, but I didn't see them or Agatha after that.
When was the next time you saw Miss Lee?
The next time that I saw Miss Lee, Agatha was in the morning. I just made coffee the same way I always did, a light Colombian roast with a small pitcher of cream and 4 sugar cubes. And then I went into her bedroom and I saw her.
Drew, I know this is going to be hard to recount, but whenever you're ready, would you please tell us what happened?
Of course. When I saw her, she was motionless. I got closer and put the coffee tray down, trying to wake her. But she wasn't moving, or she wasn't even breathing. So I went to go check her pulse, but she didn't have one. And that's when I realized she passed away. I backed up in disbelief and fell to the ground. I couldn't breathe.
What did you do next?
I half crawled and half stumbled into Miss Rogers' room. I told her the news and slid to the floor, bawling my eyes out. I eventually somehow made it back to Agatha's bedside from there. I was devastated.
What happened after you told Miss Rogers the news?
Miss Rogers, she immediately called the police. It was so fast, I didn't have time to fully process what had happened.
Did the police arrive?
Yes, they did.
And what happened after they arrived?
Miss Rogers kept telling the detective all gung-ho that it was murder. At the time, I thought that was absurd, but Miss Rogers just insisted that it was murder.
Now, I'm now putting up Exhibit 15 into evidence. Just give me one moment. Now, Mr. Drew, do you know what this is?
Yes, that is a black bag that was found in my closet by the police.
Had you seen it prior to the police showing you?
No, it was the first time I saw it. It must have been Agatha's bag.
Do you know what
Objection, Your
was
Honor,
in the
speculation.
case? I'm sorry, could you please repeat that? I didn't hear the objection.
Objection to speculation solely to the statement, it must have been Agatha's.
You have a response, counselor?
Your Honor, at this point, we are not sure who the bag is, and while I will admit that the witness is speculating, it's not for the essential truth value of the speculation.
I'm going to go ahead and sustain the objection and strike the offending testimony.
Yes, Your Honor. Now, I'm sorry, I don't believe I got an answer for that last question. Had you seen it prior to the police showing you?
No, it was the first time that I saw it. I didn't know whose it was.
Do you know what was inside the bag?
I later learned that it had cigarettes and chloroandramine.
Is this bag yours?
It absolutely was not mine. I hadn't smoked in over 7 years.
Now, did anyone else have access to your bedroom?
Like I said, the only lock that mattered to Agatha was the one about life, liberty, and property. So no, I didn't have a lock on my door. Everyone had access to it.
I'm now removing the black bag from the screen. Now, are there any other locks upstairs?
Just the one on Agatha's main bedroom door, but you could get through it through the bathroom on the side.
Would it be possible for Miss Rogers to have gone into any of these rooms while you were out with Miss Lee?
Absolutely. It would be very rude, but they could have gone to any of the upstairs rooms.
Thank you, Your Honor. No further questions at this time.
Plaintiff, cross-examination.
I can't hear you. Sorry.
My apologies. Mr. Mars, I would like to just move right in to the days surrounding when Miss Lee died, okay?
Yes, of course.
And I'd like to talk about what you knew. You knew that Miss Lee had a will, right?
Yes, I was aware of it.
You're aware of it because in 2018, Miss Lee showed you a change in her will, right?
Yes, she did. She told me that she was...
To the attorney referencing materials not yet been admitted into evidence.
May I respond? Your Honor, I don't wish to enter this into evidence. I'm simply asking the witness if they are aware of it and if they saw the change in the will.
I'm going to overrule the objection.
Yes, Your Honor.
Mr. Mars, you were aware of this change because in 2018, Miss Lee showed you her will, right?
Yes, she did.
And this change in the will meant that when Miss Lee died, you would inherit $20 million, right?
Yes, we had grown very close and she was very generous.
And Mr. Mars, you needed that money, didn't you?
Personally, no, I didn't. Miss Agatha actually compensated me very well. She gave me room and board and plus a salary of about $80,000. It was very generous, like I said.
But Mr. Mars, isn't it true that at the time of Miss Lee's death, even though she was paying you $80,000, as you said, you only had $20,000 in your savings?
Yes, like I said, I sent most of my money back home because I didn't need it for myself.
You needed that money for your sibling, right?
Yes, that's true. My sibling had terminal cancer.
And that's right, Mr. Mars. Your brother was in worse health than Miss Lee was, wasn't he?
My sister,
Objection,
but
Your Honor, to
yes.
speculation.
I'm going to overrule it for now. If we get into more specifics, then feel free to re-raise, but for now, I think we're fine.
Yes, Your Honor.
I'm sorry, Mr. Mars. Prior to trial, I was informed that your sibling was a brother. Is that correct?
I have more than one sibling, but the sister was the one that was sick.
Okay, so you were worried, or you knew that your sister was in worse health than Miss Lee, correct?
Yes, that's correct.
And Mr. Mars, you were worried that your sister would pass away before Miss Lee, weren't you?
I was worried she was going to pass away even if I got the money, to be honest.
And if your sister were to die before Miss Lee, you wouldn't be able to use that $20 million to help her, would you?
No, I wouldn't, but even that money wouldn't have been able to save her very well from terminal cancer.
I'd like to talk about your relationship with Miss Lee's grandchild, Stevie. Stevie moved into Miss Lee's home with you and Miss Lee in July of 2018, correct?
Yes, that's when Miss Rogers moved in.
And to you, Miss Lee seemed to embrace Stevie's return within a few days, right?
Yes, they were getting back to know each other again.
Miss Lee didn't seem to have time for you anymore, did she?
No, she still had time. They were spending time together, but she still had time for me too.
But she stopped spending as much time with you, right?
Well, yes, a person only has 24 hours in their day, so if some of it goes to Miss Rogers, obviously less of it would be with me.
And on August 14th, 2018, you overheard a conversation between Miss Lee and Miss Rogers in Miss Lee's study, right?
Yes, that's correct.
And on that same day, you took a trip to the pharmacy, didn't you?
I did. I had a tender date, so I had to pick up some supplies for that.
Well, Mr. Mars, I'm not asking you about your online dating habits. I'm simply asking if you went to the pharmacy after hearing that conversation, and you did, didn't you?
Yes, I did.
And you claim, Mr. Mars, that you didn't purchase the over-the-counter medication that killed Miss Lee, right?
I have never purchased chlorandramine. I don't suffer from heartburn myself, and we had to be careful around the house with it.
But you would agree that you paid in cash, right?
Yes, I did pay in cash. I don't carry a credit card on me.
And you would agree that you threw away your receipt, right?
I didn't even pick up a receipt. I try to save the planet as much as I can.
Mr. Mars, is it your testimony that you didn't pick up a receipt?
I did not take a receipt, no.
Well, you remember when you were deposed, right?
Yes, I do.
And do you recall being asked about if you had a receipt in that deposition?
Yes, and I told them no because I didn't pick one up.
Well, Mr. Mars, you recall, or do you have your deposition in front of you?
Yes, I do.
Give me one moment to find my line.
Your Honor, if I may object, I believe opposing counsel is trying to use line 293 and 294 in my witness's deposition, in which they said I paid cash. I did not save the receipt. It was a quick trip to the drugstore. This does not directly impeach my witness, nor does it go directly against the credibility of my witness statement that he did not get a receipt.
May I respond?
May.
Your Honor, this witness just said, and I quote, "Yes, I told them I didn't say, He said, I told them I didn't save a receipt because I never took one." Now, this line of the witness's deposition does say, "I paid cash, I didn't save a receipt. It was a quick trip to the drugstore." I was actually attempting to impeach this witness by omission because this witness did not say exactly what they said on the stand in their deposition.
Okay, so I'm going to let you finish your impeachment, and we can re-raise this objection once this has all been hashed out in terms of testimony. Right now, I'm still not entirely clear what the contradiction/omission is that you're going to be listening.
Yes, Your Honor.
Mr. Mars, when you answered my last question, you stated that you told the police that you didn't take a receipt. Is that right?
No, I said I didn't have a receipt, and then I explained why I didn't have a receipt, which is because I didn't take one.
But that's not what you said in your deposition, was it?
I said specifically I didn't save a receipt and then I didn't say anything else, but the reason I didn't save the receipt is because I didn't take one.
Well, Mr. Mars, I never asked you the reason why you didn't save your receipt. I simply asked if you told detectives that you did not save your receipt. And that's what you said, right?
No, you said that I took a receipt, and I'm telling you that I didn't take a receipt.
All right, Mr. Mars, let's just move on. regardless of if you admit that you purchased this over-the-counter medication, you admit that Miss Lee takes a prescription arthritis medication that looked the same, right?
Yes, Winterin, 250 milligrams.
They're the same color.
They are both off shade of purple, yes.
They are the same shape.
Yes, they are.
They weigh the same thing.
They're both 250 milligrams, yes.
In fact, Mr. Mars, to the naked eye, these medications are identical, right?
Unless you have some advanced pharmaceutical license, that's true.
Now, you also knew that that Miss Lee had a severe allergy to this over-the-counter medication, right?
Yes, I am aware of that.
You knew that because you're aware that she suffered a heart attack after taking just one of these pills previously, right?
Yes, that's actually how I came in contact with Miss Lee in the first place. After her heart attack, she was looking for a caretaker, so I applied for the job and I got it.
So you're aware that if one pill caused a heart attack, 2 pills would be certain to cause the death of Miss Lee, right?
Well, I'm not a doctor, I'm just a nurse, but I'm sure that would happen. Even one pill should have killed her, to be honest.
Well, Mr. Mars, isn't it true that you told Stevie Rogers that 2 pills would certainly kill her grandmother?
I did tell Stevie that 2 pills would kill her grandmother, so Stevie knew that.
Now, I just want to be very clear. 12 hours after you went to the pharmacy, where you paid in cash and didn't take a receipt, Miss Lee was found dead, right?
Yes, unfortunately, that is true.
Thank you. I have no further questions.
Any redirect?
No redirect, Your Honor. I just asked that my witness be allowed to step down.
Your excuse, Mr. Mars. Thank you.
Thank you, Your Honor.
Defense, feel free to call your next witness. I would also remind both sides of the clock. So just keep that in mind when you're doing direct and cross, that we are a bit short on time.
Yes, Your Honor. Do you know what time all loss is?
From what I understand, all loss is 5:13 p.m. EST.
Yes, Your
Yes,
Honor.
that's
Thank you.
correct.
Thank you. Now at this time, the defense would like to call Ryan Cabrera to the stand. May I begin, Your Honor?
You may.
Thank you. Good afternoon. Please introduce yourself.
Hello, I'm Ryan Cabrera. I'm a professional biographer.
Now, Ms. Cabrera, how did you become involved in this lawsuit?
Oh, well, I was just doing my job. Until she passed, I was writing the biography of Agatha Lee. Can you believe that? I had the exclusive scoop on her life.
And could you please explain who Agatha Lee is for the jury?
Of course. If you haven't heard of her, Miss Agatha Lee is one of the best-selling American mystery authors. She wrote Death in a Bottle, the mystery novel. That was in 1968. After that, she became pretty private, so no one really heard from her. That's where my biography comes in. I am covering the later half of her life. That's never been covered before.
Now, how did you first come into contact with Agatha Lee?
Well, she was pretty private. So in 2015, I sent a letter to her publisher, and I said, please pass this message. I want to do the biography of Agatha Lee. And they, I guess, passed the message because 3 years later, I was pretty persistent. They came in and gave me the response that Agatha would accept my biography writing, and I went to meet her in Midlands.
So you came to Midlands to study Agatha Lee. How did you meet with her?
Well, a couple times a week, every week, we met up at her house or a local restaurant or the campgrounds, and we just had conversations. We talked about her life, my life, everything.
Now, while you were getting to know Miss Lee, how did you perceive her relationship to be with her caretaker, Drew Mars?
Oh, honestly, if you didn't know who Drew was and you saw them together, you would think they were like a grandparent and grandchild. Drew was so close with Agatha, and Agatha loved Drew. She told me herself. it was beautiful.
And do you know if anyone else was living at Lee Manor at the time that Agatha Lee died?
Not for a while, but then in July 4th, Stevie Rogers moved in. So it was just Agatha and Drew. And then in July, Stevie joined that. And so I guess around when Agatha died, it was the three of them.
And Miss Cabrera, to your knowledge, who is Stevie Rogers?
I know Miss Rogers just as Agatha's grandchild and the only surviving relative.
Did you ever learn anything about Miss Rogers?
Well, through our conversations, Agatha opened up sometimes. Agatha told me that Stevie and her were really close when Stevie was young, but Stevie was a little bit lazy and spoiled. So after Stevie's mom died in the car crash, they lost touch, and Stevie basically abandoned Agatha. So Agatha removed Stevie from her will in 2018.
All right. And how did you come across the contents of Agatha's will?
Just another conversation we had together. One time Agatha showed me her will, her old will that had Stevie as the heir, then her new will had Drew Mars as the heir, and then she showed me a letter from Agatha to Stevie explaining the change in the wills.
And would you recognize the two wills you just mentioned if I were to show them to you today?
Oh, definitely. I've seen them before.
Attorney Musto, could you please pull those up for me? That's all right. I can pull them myself.
I have it. Just give me one moment.
Thank you. All right. Can you see those up on the screen, Ms. Cabrera?
Yes, I can. Those are the two wills. I've seen both of them before. Yep.
And they appear the same way that you saw them when Agatha Lee showed them to you?
Yes, they do. Same witnesses. Yep.
All right, Your Honor, at this time, the defense offers both Exhibits 8 and 9 into evidence as full exhibits.
Any objection?
No, Your Honor.
We'll accept both 8 and 9 into evidence.
Thank you, Your Honor. Now, Ms. Cabrera, could you please describe to the jury any substantive differences you see between these two exhibits or two wills?
Yeah, the biggest differences in here is that the first will in 2008 has Stevie Rogers as the whole heir to everything. But then the will in 2018, the revised one, has Drew Mars as the heir and excludes Stevie Rogers.
All right, thank you, Ms. Cabrera. Now, Ms. Cabrera, you also mentioned the letter, correct?
Oh yeah, saw that too.
And would you recognize that letter if I were to show it to you today?
Yes, I would.
Attorney Musto, can you please pull that one up as well? Thank you. Now, Ms. Cabrera, can you see that document on the screen?
Yes, I can.
Now, it's a little bit redacted from what you've probably seen before, but do you recall reading this letter with Agatha Lee?
Oh yes, I can recognize it.
Now, to the best of your recollection, what did the letter read when you read it with Agatha Lee?
Well, I remember it being about Agatha explaining to Stevie Rogers the changes in the will. So basically, Agatha told Stevie that they were becoming family in name only, and Agatha was going to remove Stevie from her will.
All right, thank you. That can be taken down now. Now, Ms. Cabrera, did you ever meet Miss Rogers in person?
I met Stevie Rogers on July 6th.
And how did Agatha react to Stevie Rogers coming back into her life?
Oh, Agatha was the happiest I'd seen her the whole time I'd known her. She was glad to be reconnecting with Stevie. She said they did a lot together when Stevie came back.
And how did Drew Mars react to Miss Rogers' arrival to Lee Manor?
Well, I had one interaction with Drew Mars where I was saying to Drew, like, isn't this great how happy Agatha is with Stevie? And Drew was just a little worried. Drew said, like, I think Rogers is only here for Agatha's money. So, I mean, I'm not surprised he was protective. He worked for her for 10 years as the caretaker, but he didn't seem very happy.
And when did you and Miss Agatha Lee stop meeting?
We didn't, I guess. I mean, we met the day she died, and we had another meeting planned for the following week.
And so how did you find out about Agatha's death?
Drew called me. The poor guy I barely understood what he said on the phone. It was really, really upsetting to hear him so sad.
And are you still writing Agatha's biography?
Oh, of course. See, this is the thing. It's a tragedy to lose her, but we need to do her life justice. So I'm going to finish her story. I'm finishing the biography to include the mystery behind her death. It's sort of fitting.
And have you been following the investigation into her death?
Yes, that's how I'm getting all my information for the rest of the biography. From what I've gathered, her death played out exactly the same way that Carrie Bellion died in Death in a Bottle. That's Agatha's mystery novel, the one she published. The only thing is we don't know who the killer is yet. I still have to write the last pages.
Thank you, Ms. Cabrera. Now, at this time, Your Honor, I'd like to constructively offer Exhibit 7 into evidence to publish to the jury, but even though it has been previously admitted.
Yes, it's been previously admitted. It'll be published to the jury.
Thank you, Your Honor. No further questions at this time.
Cross?
Yes, Your Honor. Ms. Cabrera, as you mentioned earlier, you were writing a biography about Miss Lee, right?
Yes.
And you met with her many times to discuss that biography.
Oh, yes, we met several times a week in the height of it. It was riveting. She had so much to say about her life, and I was so glad to hear it.
I'd like to talk about something you saw in May of 2018 during one of those meetings.
Oh, sure.
Excuse me. You witnessed the defendant giving Miss Lee a purple pill, right?
Oh, yeah. I did see that.
And the defendant began to tell Miss Lee what the pill was, right?
Yes.
But Miss Lee cut him off, right?
Well, it wasn't really I don't know. When I cut somebody off, it sort of seems sort of mean, but she just was like, oh, that's okay. Really nice about it.
But Miss Lee interrupted what he was saying, right?
Yeah.
And she said, I'll take...
Objection, Your Honor. The attorney is calling for hearsay.
Your response?
Yes, Your Honor, this is an exception to hearsay under Rule 803.3. It is a statement of intent by Miss Lee to take whatever the defendant would hand to her. I didn't finish the statement, but that's what the rest of the statement is.
Okay, if that's a statement, then I am going to overrule the objection.
Yes, Your Honor.
Immediately after interrupting the defendant, Miss Lee said, I'll take whatever you hand me, right?
That is what she said. Like I said, they had such a sweet relationship.
You had lunch with Miss Lee on August 14th, 2018, right?
Oh, yeah. It's heart-wrenching to think about now because that's the day that she died. But I loved our meetings.
Well, that was the day before Miss Lee was found dead, right?
Yes.
So the day before Miss Lee was found dead, she told you she was going to meet with her lawyer?
Objection,
Oh, yeah.
Your Honor. This is also hearsay.
You have a response?
Yes, Your Honor. This is also an exception to hearsay under Rule 803.3, as it is a statement of Miss Lee's intent to meet with her lawyer.
I'm going to agree and overrule the objection.
Yes,
So
Your
the
Honor.
the day before Miss Lee was found dead, she told you she was going to meet with her lawyer, right?
Yes, at our meeting that day.
She said, I'm meeting with my lawyer Friday, right?
She did say that.
But Miss Lee died before Friday, didn't she?
Yes. Like I said, she died that night.
Less than a week after that lunch, you attended the reading of Miss Lee's will.
Oh, I was honored to be admitted to that. It's adding so much to my biography of her.
At the reading of the will, everything was left to the defendant, right?
Yes, it was.
Let's fast forward to 2 months ago, June of 2020. The defendant called you, right?
In June? Yes.
And that was when the defendant asked you to testify on his behalf in this trial.
Yes, yeah, sorry. Drew called me and asked me to testify.
You said yes, right?
I mean, I felt that if asked, I could share what I knew. We weren't very close, but I was part of Agatha's life for a couple months there.
So you did say yes.
Yes, I said yes.
And you're here testifying willingly.
Yes, like I said, if I have something to share, I'll share it.
But you stand to gain something if the defense wins today, don't you?
I don't quite understand what you're saying.
Well, 2 months ago, right after the defendant asked you to testify, he asked you a question, didn't he?
Yeah, well, Drew offered that, asked if I'd like anything from Agatha's estate.
And before Miss Lee passed, you discovered that she had unpublished books, right?
Oh, that was like quite the discovery. Yes.
Well, and that's because Miss Lee only ever published one book, right?
This is true. Yep.
Those unpublished books were on the bookshelf in Miss Lee's study, right?
Yes, that's what she told me one day. That she said she wrote a couple other books and they were in her study, and I would love to read those.
Well, you actually saw those unpublished books on the bookshelf when you were in the study for the will reading.
Objection, Your Honor. To relevance, this line of question has been going on for some time, and I don't exactly see the relevance just yet.
I'm going to overrule for now, but ask you to make your point quickly or move on.
Thank you, Your Honor.
You believed that these unpublished books could be valuable, didn't you?
Well, I honestly, yeah, I had the inkling because of Agatha's previous book, but I had no idea until I was able, like, I need to read them, before you can understand if they're actually as good as the previous or really worth anything.
Well, Ms. Cabrera, you would say that you can't fathom how much those books might be worth?
Well, they're priceless to me. I mean, any unpublished novel by someone so skilled as Agatha, they're priceless.
So when the defendant asked you if you would like anything from Miss Lee's estate, you asked for those books, didn't you?
Oh, I asked for all of Agatha's books. She had such a literary taste. I mean, I work at a library besides writing my biography, and I understand like the appreciation for books, if you know what I'm saying. So just to have access to her library and to read what she read, it would be amazing.
After you asked for the entirety of Miss Lee's private collection, the defendant responded, if the civil trial ends and I am still in possession of Agatha's estate, those books are all yours, right?
Yeah, that's what he said. It was so sweet of him to offer. I was honestly amazed but Drew's already told me that it was so much that she had offered him, he might as well offer me. It was very sweet of him.
So to be clear, Ms. Cabrera, as far as you're aware, if the defendant wins the case today, you will receive all of those unfathomably valuable unpublished books, won't you?
Objection, Your Honor. To lack of personal knowledge, this witness is not a lawyer and doesn't understand or have any knowledge of legal proceedings, and therefore I don't think they can exactly explain or have knowledge of how this trial would end up or what would happen in either eventuality.
I'm going to overrule the objection. If the witness does not know, she can say so.
Yes, Your Honor.
So, Ms. Cabrera, to your understanding, if the defendant wins this case, you will receive those books, won't you?
All I know is, like Drew said, after the trial ends, so I guess it depends if he's in possession of them. I'm really not quite sure. He just says after the trial, so I figured I would call him up afterwards and see how everything was going.
Thank you, Ms. Cabrera. I have no further questions.
Great. Any redirect?
No to redirect, Your Honor. We only ask that the witness is allowed to step down.
He may step down. And with that, we'll move right into closing arguments. And just a reminder for everyone to switch back into speaker view. Given the time that we currently have, we would ask both sides to shorten their closing arguments and say that we do 4 minutes for each so that we finish by the time of all loss.
Do we have enough time? I thought all loss was at 4:13.
Yeah, so right now it is 5:06 and all us is at 5:13. So like we may need to do 3 minutes. It may need to be really short.
That's fine.
Oh,
Let's go with 3 minutes.
Okay.
And
Totally fine.
okay.
For purposes of using my time wisely, I'm going to go ahead and get my PowerPoint ready to share. Okay. May it please the court, counsel, members of the jury. Now, you've heard a lot of back and forth today, so we're just going to get right to the point of why we're here today. Stevie Rogers is suing the defendant Drew Mars for the wrongful death of her grandmother, Agatha Lee. So what exactly does this mean? First, in a wrongful death suit, we need to ask ourselves, has somebody died from unnatural causes? And if so, is that significant? Now, Miss Lee died from an overdose to an over-the-counter heartburn medication. Members of the jury, this tells us some crucial information about her killer. This tells us that her killer had to know about the allergy. Her killer had to know that, or had to have access to her medication, and had to know enough about the two medications to make that switch. Members of the jury, this also means that the killer had to handle the medication. And that's where the proof comes in. Those two partial prints that the defendant left on the medication that Miss Lee should have taken that night. So we've established by a preponderance of the evidence that somebody has died of unnatural causes. The bigger question is, did the defendant commit these? Did the defendant knowingly cause the death of Miss Lee? Now, Midland's Penal Code defines knowingly as actions that a person is practically certain will produce a certain outcome. Now, in order to determine whether or not the defendant acted knowingly, we must look at Miss Lee's last day of life. August 14th, 2018. 11:30 a.m., the defendant leaves Lee Manor with Miss Lee to take Miss Lee to lunch. A half hour later, the defendant drops Miss Lee off to have lunch, and an hour and a half later arrives back to pick Miss Lee up. At 2 p.m., they get back to Lee Manor, and at 6:30 p.m., the defendant serves Miss Lee and Miss Rogers dinner. We know that the defendant was seen at 9:35 p.m. by Miss Rogers, but members of the jury, the defendant stated they didn't see Miss Lee after this point. So why lie? It would have been normal for the caretaker to enter the bedroom, so why lie if you weren't doing something you shouldn't have been doing? Well, let's look at what the defendant did earlier that day to answer that question, members of the jury. Before ever leaving for lunch, the defendant hears Miss Lee say that she is leaving her estate to Miss Rogers. This infuriates the defendant, but he thinks it might not be true until he hears a phone call in which Miss Lee makes an appointment with her attorney. And then the defendant visits a local pharmacy, pays in cash, and doesn't keep a receipt. Members of the jury, the proof is in those pills. Hold the defendant accountable. Thank you.
thank you, Ms. Wondrow. Defense?
Yes, Your Honor. Your Honor, opposing counsel, members of the jury, may it please the court. Now, the plaintiff just came up here and told you that, and even in the beginning of today's trial, that if I have it down right, that the proof was in the prints and that the prints were on the pills. Now, I ask you, members of the jury, what did you hear about prints in today's trial? Well, let's go back to that. You heard that there was prints from Drew Mars, the defendant, found on the pills of Winterin, the arthritis medication that Agatha Lee took. Well, if you're someone's caretaker and you handle their pills on a daily basis, isn't it expected to find their fingerprints on those pills? If you serve yourself some pills or take some pills yourself, wouldn't your fingerprints be on any in the bottle that you take out? I think that's completely normal, ladies and gentlemen of the jury. Now, the only other prints, so far we've shown that there are no prints, there is a single print. And that print is on a black bag that the plaintiff would have you believe was owned by Drew Mars. Now, Drew Mars has already told you they don't know where that bag came from. They don't know whose it is, and they have never purchased Winterin or any of the contents of the bag at all. Now, fingerprint analysis suggested that there was a single fingerprint on that black bag from Drew Mars, on the zipper of the bag. Now, ladies and gentlemen of the jury, can you open a zipper with a single finger? I don't think so. So when the plaintiff is coming up here and telling you that the fingerprints are what point the finger at Drew Mars, I ask you to think again and reconsider what the fingerprints are actually telling you. Now, us as the defense, we bear no burden in today's case, but we still offered you evidence to prove that our defendant, Drew Mars, had nothing to do with the death of Agatha Lee. In fact, we told you that Stevie Rogers, Agatha Lee's granddaughter, was family in name only. Now, after being removed from her will, she was distraught and spent 7 years away from Agatha Lee, not calling, not texting, yet spontaneously arriving at the door of Agatha Lee just a few months before she died. And you also heard from Drew Mars and various other witnesses that Stevie Rogers asked to be replaced in the will. Now, you heard from Drew Mars, who was right outside and overheard that conversation, that request was denied. So, with Stevie Rogers being well aware of the Slayer statute and Agatha Lee dying days later and now suing Drew Mars to take advantage of that Slayer statute, we see where the evidence points. And that's why the defense asks you to find Drew Mars not liable in today's case. Thank you.
Thank you so much. Judges, you should please complete your ballot and submit your ballots. And I'll ask everyone to stay on until everyone has submitted their ballots, and then we'll do brief comments. For now, the bailiff will take over to make sure we all submit everything.
Yeah, so I'm going to go ahead and send the students to their breakout rooms so that they can just hang out there while all of the ballots get submitted. I'm also going to